Well, now let's take a look also in the United Kingdom and UK. We have a lot of copyright litigation, and Nick, you're an expert in that area, and you've handled many important cases. Give us an update, please, on some of the key copyright infringement cases from the United Kingdom.
Well, the first case was an absolute cause célèbre. It was concerning breach of copyright of the Da Vinci Code. A book had been written in 1982 by the claimants called The Holy Blood and Holy Grail, which I'm sure everybody here has read. And it's all about the Cathars and the Albigensian Crusades, the early Christian church, the Priory of Sarum behind the Knights Templar, and all that sort of good stuff. And Da Vinci Code was published in 2003. And they claimed that a substantial part of Da Vinci Code had been taken from the prior work, The Holy Blood and Holy Grail. Particularly the central theme, they said, had been copied. It came for trial before someone called Mr. Justice Peter Smith, who is, if you didn't know him beforehand, you'd certainly realize after his judgment that he's probably stark staring bonkers. He took a mere 3 weeks to deliver his 70-page judgment, and in the course of it, he himself included a code, something about the HMS Dreadnought, which was a ship of the First World War fighting. And the Court of Appeal said, remarking about his judgment, that the judgment is not easy to read or understand. It might have been preferable for him to have allowed more time for the preparation and checking and revision of the judgment, which is judicial code for saying your chances of promotion to the Court of Appeal are absolutely zero. Despite that damning indictment of the style of his judgment, they actually agreed with his conclusions that there had been no substantial copying. And the case is really concerned with what rights are there for historians, or in this case, quasi-historians, because The Holy Blood and the Holy Grail is a book of historical conjecture. It's not actually historical fact. What rights do they have to the fruits of their research? And it was really summed up by Lord Justice Mummery, who is the intellectual property judge of the Court of Appeal. And he said the position is that individual elements of the central themes distilled from the Holy Blood and the Holy Grail are not sufficiently developed in character to constitute a substantial part of the Holy Blood and the Holy Grail. In the words of the judge, they are too generalized to be a substantial part of the Holy Blood and Holy Grail. They are an assortment of items of historical fact and information, virtual history, events, incidents, theories, arguments, and propositions. They do not contain detailed similarities of language or architectural similarities in the detailed treatment or development of the collection or arrangements of incidents, situations, characters, and narrative, such as normally found in cases in infringement of literary or dramatic copyright. The 11 aspects of the central theme in Da Vinci Code are differently expressed, collected, selected, arranged, and narrated. So they said that the literary copyright that exists in the Holy Blood and the Holy Grail, by reason of the skill, labor expended by the claimants in the original composition and production of it, and the original manner or form of expression of the results of their research. But original expression does not include only the language in which the work is composed, but also the original selection, arrangement, and compilation of the raw research material. It does not, however, extend to clothing information, facts, ideas, theories, and themes with exclusive property rights, so as to enable the claimants to monopolize the historical research or knowledge and prevent the legitimate use of historical and biographical material, theories propounded, general arguments deployed, or general hypotheses suggested, or general themes written about. The big point about this is there was no actual textual copying, so they had a really uphill struggle to win that case at all. And what we think the case is really all about was the authors of the Holy Blood and Holy Grail wishing to generate publicity for their book on the back of the Da Vinci Code. And the real issue that us litigation lawyers want to know is whether the costs which they had to pay the defendants when they lost the case actually were greater or lesser than the additional royalties they gained from bringing the case in the first place.
This is interesting because we've had, as you talk about this, Nick, this case, we've just had in the last few days a ruling on the Da Vinci Code, a copyright infringement case here in the U.S., the U.S. District Court for the District of Massachusetts. There was a lawsuit, the plaintiff's book was called The Vatican Boys, And what's important here and interesting is that the plaintiff proceeded, part of this case was about something called, a theory called structural or thematic similarity, not the word substantial similarity. And the judge said, wait a minute, I'm not even going to get structural or thematic similarity. That's awfully general when you get down to it. The plaintiff hasn't showed me a case dealing with those concepts, and I haven't found one. So that case ended up being where the plaintiff lost. So we've had 2 wins here for Dan Brown.
Sure. Okay, now the next case should be accompanied by a little bit of music. Thank you very much indeed. Hands up anybody in the audience who doesn't know what that song is. One of the most famous songs ever recorded, A Whiter Shade of Pale. Okay, that's fine. It is actually more fun than listening to me, but that came out in May 1967, and it is said that John Lennon was driving in his car when he heard it coming over the airwaves, and he pulled into a siding to listen to it, and then he rang up Paul McCartney, not from his mobile phone, I can assure you, and said, gosh, why can't we write songs like that? It became a completely cult song. That version by Procol Harum sold over 6 million copies, and it has been covered over 770 times by other pop groups. The song copyright was credited to Gary Brooker, who is the guy who plays the piano on the track you just heard and who sings, and the lyrics were credited and written by someone called Keith Reed, and nothing turns on the lyrics. Matthew Fisher is the organ player, and he was not credited with the creation. The judge did, however, find, not surprisingly, that the organ solo is a distinctive and significant contribution to the overall composition, and was the product of skill and labor on the person who created it, which was probably, frankly, J.S. Bach. The 2 central themes
which band was he in?
He was in the Vienna Rockers.
That's right.
That well-known pop group with Mozart on bass. And the 2 questions which the judge had to wrestle with were who had composed the organ solo, and secondly, was it possible to have a fair trial? Because what you may have noticed about this case, the chap, Matthew Fisher, didn't sue until March 2004, and if you do the maths, the difference between 1967 and 2004 is a mere 37 years. Hands up anybody in this audience who's younger than 37. So the issue is whether there could be a fair trial. We'll be coming to another case shortly, which we handled about the Barretts suing the Bob Marley family, where very similar issues arose. But the judge in this case held that a fair trial was possible because all the relevant witnesses were still alive and actually recalled what had happened quite well. It was remarkable that he hadn't protested this matter for 37 years. I believe he got negligent advice, probably, so hopefully there's another lawsuit going to follow there against some firm of solicitors in England. Not mine, I can assure you. The judge so he said that it was possible to have a fair trial, and the trial proceeded, and the evidence was duly given. And there was no dispute that Fisher had written that beautiful organ descending line, but Brooker said that it had actually been taken from a bass line that he, Brooker, had put down earlier. It was a pure question of fact at the end of the day, and the judge held in favor of Matthew Fisher, i.e. the organist, and said that he was entitled to a 40% share of the musical copyright in that song. However, because he had delayed, the normal rule in English legal procedure is you can go back 6 years from the date of issue of the writ and claim an accounting of royalties for 6 years and then going forward to the future. The judge found, as a matter of justice, because he has a discretion for restitutory remedies, that actually the royalties should start being paid to Fisher from the date of the issue of the court proceedings, which was in May 2005. So that was the way the judge compromised on the severe delay position.
The test for to be a joint author, isn't that what this is? In the United Kingdom, Nick, it wasn't this case, part of it was the sweat of the brow doctrine is accepted, because in the U.S. here, that's not really a big issue. There are other elements that are used for co-authorship.
Yes, I mean, it's not only the sweat of the brow, it's actually who did invent that tune. That was the dispute. That was the battle between the two parties. Who actually wrote those lines? They both admitted that it was really J.S. Bach, but, well, it was derived from one of his organ pieces. But at the end of the day, the judge found it was almost a prior access point, that he had not had access to the bass line that Fisher had written, and so, you know, Brooker prevailed. Sorry, Fisher prevailed. The organist prevailed.
Right.
So that's Whiter Shade of Pale.